Kansas versus Hendricks, Supreme Court of the United States, 521 U.S. 346, 1997. Justice Thomas delivered the opinion of the court. In 1994, Kansas enacted the Sexually Violent Predator Act, which establishes procedures for the civil commitment of persons who, due to a mental abnormality or personality disorder, are likely to engage in, quote, predatory acts of sexual violence. Kansas State and 5929A01, 1994. The state invoked the act for the first time to commit Leroy Hendricks, an inmate who had a long history of sexually molesting children and who was scheduled for release from prison shortly after the act became law. Hendricks challenged his commitment on double jeopardy and ex post facto grounds. The Kansas Supreme Court invalidated the act, holding that its pre-commitment condition of a mental abnormality, quote, did not satisfy what the court perceived to be the, quote, substantive due process requirement that involuntary civil commitment must be predicated on a finding of, quote, mental illness, end quote. We now reverse. The Kansas legislature enacted the Sexually Violent Predator Act in 1994 to grapple with the problem of managing repeat sexual offenders. In the Act's preamble, the legislator explained, a small but extremely dangerous group of sexually violent predators exists who do not have a mental disease or defect that renders them appropriate for involuntary treatment pursuant to the General Involuntary Civil Commitment Statute. In contrast to persons appropriate for civil commitment under the General Involuntary Civil Commitment Statute, sexually violent predators generally have antisocial personality features which are unamenable to existing mental illness treatment modalities, and those features render them likely to engage in sexually violent behavior. The legislator further finds that sexually violent predators' likelihood of engaging in repeat acts of predatory sexual violence is high. The existing involuntary commitment procedure is inadequate to address the risk of these sexually violent predators pose to society. Hendricks admitted that he had repeatedly abused children whenever he was not confined. He explained that when he, quote, gets stressed out, he, quote, can't control the urge, end quote, to molest children. Although Hendricks recognized that his behavior harms children, and he hoped he would not sexually molest children again, he stated that the only sure way he could keep from sexually abusing children in the future was, quote, to die, end quote. Hendricks readily agreed with the state's physician's diagnosis that he suffers from pedophilia and that he is not cured of the condition. Indeed, he told the physician that, quote, treatment is bull, end quote. The jury unanimously found beyond a reasonable doubt that Hendricks was a sexually violent predator. The trial court subsequently determined as a matter of state law that pedophilia qualifies as a mental abnormality as defined by the Act, and thus ordered Hendricks committed to the Secretary's custody. Kansas argues that the Act's definition of, quote, mental abnormality satisfies substantive due process requirements. We agree. Although freedom from physical restraint has always been at the core of the liberty protected by the Due Process Clause from arbitrary governmental action, Fosha v. Louisiana 504 U.S. 71, 1992, that liberty interest is not absolute. Accordingly, states have a certain narrow circumstances provided for the forcible civil detainment of people who are unable to control their behavior and who thereby pose a danger to the public health and safety. We granted Hendricks' cross petition to determine whether the Act violates the Constitution's double jeopardy prohibition, or its ban on ex post facto lawmaking. The thrust of Hendricks' argument is that the Act establishes criminal proceedings, hence confinement under it does necessarily constitutes punishment. He contends that whereas here newly enacted punishment is predicated upon past conduct for which he has already been convicted and forced to serve a prison sentence, the Constitution's double jeopardy and ex post facto clauses are violated. We are unpersuaded by Hendricks' argument that Kansas has established criminal proceedings. Commitment under the Act does not implicate either of the two primary objectives of criminal punishment, retribution or deterrence. The Act's purpose is not retributive because it does not affix culpability for prior criminal conduct. Instead, such conduct is used solely for evidentiary purposes, either to demonstrate that a mental abnormality exists or to support a finding of future dangerousness. In addition, the Kansas Act does not make a criminal conviction a prerequisite for commitment. Persons absolved of criminal responsibility may nonetheless be subject to confinement under the Act. An absence of the necessary criminal responsibility suggests that the state is not seeking retribution for a past misdeed. Thus, the fact that the act may be tied to criminal activity is insufficient to render the statute punitive. United States versus Ursary 518 U.S. 267-291, 1996. Moreover, unlike a criminal statute, no finding of scienter is required to commit an individual who is found to be sexually violent predator. Instead, the commitment determination is made based on a mental abnormality or personality disorder rather than one's criminal intent. The existence of a scienter requirement is customarily an important element in distinguishing criminal from civil statutes. The absence of such a requirement here is evidence that confinement under the statute is not intended to be retributive, nor can it be said that the legislator intended the act to function as a deterrent. Those persons committed under the act are by definition suffering from a mental abnormality or a personality disorder that prevents them from exercising adequate control over their behavior. Such persons are therefore unlikely to be deterred by the threat of confinement, and the conditions surrounding that confinement do not suggest a punitive purpose on the state's part. The state has represented that an individual confined under the act is not subject to the more restrictive conditions placed on state prisoners, but instead experiences essentially the same conditions as any involuntarily committed patient in the state mental institution. Although the civil commitment scheme is at issue here does involve an affirmative restraint, the mere fact that a person is detained does not inexorably lead to the conclusion that the government has imposed punishment. United States versus Salerno 481 U.S. 739, 1987. The state may take measures to restrict the freedom of the dangerously mentally ill. If detention for the purpose of protecting the community from harm necessarily constituted punishment, then all involuntary civil commitments would have to be considered punishment. We therefore hold that the Act does not establish criminal proceedings and that involuntary confinement pursuant to the Act is not punitive. Our conclusion that the Act is non-punitive thus removes the essential prerequisite for both Hendricks' double jeopardy and ex post facto claims.